Welcome to the Norwegian British Chamber of Commerce and Dorsey and Whitney webinar, Trump 2.0, Expected Impacts on U.S. Trade Policy. I'd like to introduce Kira Haugen, the General Manager of the Norwegian British Chamber of Commerce. Take it away.
Thank you. Welcome, everyone. It's a pleasure to kick off this highly relevant and timely webinar, hosted by, in collaboration with Dorsey & Whitney, one of NBCC's long-standing partner members. For those new to NBCC, we are a business membership organization and an integral part of Team Nova UK, dedicated to foster collaboration and knowledge sharing between Nova and the UK. We are delighted to have Dorsey's expertise guiding today's discussion, and without further ado, I'd like to hand over to Karsten, partner at Dorsey & Whitney and NBC Council member. Karsten, over to you.
Thank you, Kira, and welcome everyone to this webinar. We're delighted to be co-hosting it with the NBCC. Just a couple of housekeeping things before I hand over to the speakers. As you can see here, today's program is 60 minutes. We will hopefully do a little bit of Q&A if we have time. So if you have questions as we go through, if you could please submit them using the chat, and then we will either try and go through them as we go, or we will try and cover them at the end, or if we don't get to them, we will save them down and look to come back to you if we can afterwards. The materials from the session, including this recording, will be available for download from the survey email that will be sent from events@dorsey.com, and will also be posted on Dorsey's website and on the NBCC's website after the program. I want to say that we are delighted to be doing this with the NBCC. Many of you are maybe not members of the NBCC. If you're not, get in contact with Kira if you are keen to join. Everyone is welcome, whether you're based in Norway or in Britain or elsewhere. And yeah, on that, I will hand over to my colleague Dave Townsend, who will do the first part of the presentation.
Thank you very much, Karsten, and thanks to the NBCC for hosting this. And we're thrilled to have the opportunity to give an update of sorts on U.S. trade policy. It's obviously a fast-moving area. We're joking ahead of the meeting that things are moving so fast. This is sort of a snapshot and might be obsolete by next week, but we will give you an update about where things stand today and what's happened thus far. We'll be giving we'll touch on a little bit of what happened in the first Trump administration and how that might guide what we expect to happen in the second Trump administration with respect to U.S. trade policy. As of right now, there are, as you've probably read in the news, there are new tariffs that have already been imposed on China. There are tariffs that have been deferred over the next 30 days with respect to Canada and Mexico, and there's significant talk about additional tariffs beyond that. So we're going to tell you what's happened over the last week, really, or 2 weeks, I should say, since the Trump administration came into office. We're going to talk a little bit about the basis for the changes in U.S. trade policy and how difficult it is for businesses to predict, what is coming next. That will be the first half, and then the second half of the program, we're going to go over some potential mitigation strategies and things for businesses to think about as U.S. trade policy changes that could offer you opportunities to potentially save in terms of tariff liability or at least manage the risk better. So the first thing, there was a lot of talk by President Trump and candidate Trump in his campaign to become president about tariffs. He frequently talks about it and had said after he was elected president that he planned to impose tariffs potentially as early as day one. A lot of people expected, including myself, frankly, that he would impose tariffs on day one. In fact, he didn't. What he did instead was issued what he called his America First trade policy. And this was one of the first things that he signed after being sworn in as president of the United States. So what does this say? It's really a far-reaching memorandum and intended to sort of set the stage for action on U.S. trade policy for a number of reasons and using a number of potential legal authorities. The memorandum phrases or frames, I should say, U.S. trade policy as being focused on reciprocal market access. That is, the United States will expect market access in foreign markets on terms similar to what it offers to foreign countries. Traditionally in the United States, we've kept a low tariff policy, low tariff rates generally, an average tariff rate that is relatively low. And I think the America First trade policy signals that may be coming to an end. It calls for a potential what's called global supplemental tariff, by that meaning a tariff that would apply to everything coming into the United States, and also calls for some pretty significant administrative changes, including the establishment of what would be called the External Revenue Service, which would be focused on collecting tariffs on goods as they come into the United States. So, what is the basis for action here in this memorandum? And it provides a whole host of reasons that the United States may reconsider its current trade policy. This includes large and persistent trade deficits, alleged unfair practices, review of free trade agreements, including the USMCA that the United States has with Mexico and Canada, exchange rate imbalances, making sure that the United States industrial and manufacturing base is sufficient for national security needs and also sufficient for, I think, economic health, not just national security. And then also potentially new national security related export controls and investment restrictions. So this memorandum really provides a broad basis for new action in U.S. trade policy. It establishes and requires that certain U.S. departments and agencies produce reports and information for the president. Many of the deadlines are as of April 4th, so it gives them about 3 months, a little less, to produce a report to the president on these key issues that I've outlined here. And then presumably, based on those reports and assessments of these key issues, there would be potential changes to U.S. trade policy. And we'll go over later in the presentation some of the legal bases for these and the timelines for them. So with that, I'm going to turn it over to my colleague, Augustine Lowe. Augustine, if you could introduce yourself and then go ahead and talk about what's happened thus far and last week.
Thanks, Dave. So I'm Augustine Lowe, also a partner in Dorsey's International Trade and National Security practice. I'm based in Seattle, and that's what you see in the background, the Port of Seattle. Prior to joining private practice, I was a lawyer in the Office of Chief Counsel at U.S. Customs and Border Protection, Washington, D.C., and that is the primary agency for enforcing customs tariffs and other laws. Soon to be seeing what would happen if Trump creates a new External Revenue Service and how that relates to the existing CBP agency, but well, that remains to be seen. So here, we're going to talk about some of the bases and how Trump tried to impose tariffs recently on Canada, Mexico, and how the tariffs are being imposed on China, specifically the goods coming from those countries. To establish these tariffs, President Trump invoked emergency powers under the International Emergency Economic Powers Act, or IEEPA, That statute allows a U.S. president to impose extraordinary measures by declaring an emergency with respect to some threat to U.S. security coming from abroad. So historically, this has been applied to countries like, say North Korea, Iran, other adversaries, and also hostile foreign actors, typically resulting in some prohibition against certain classes of transactions. But very seldom has it ever been used, or in fact, probably never, to impose tariffs on foreign goods entering the United States. And so on his first day in office, as Dave said, Trump issued his America First trade policy, which previewed these actions. He claimed that there was a national emergency with respect to fentanyl and other drug trafficking crossing the border, as well as illegal border crossings by foreign persons crossing the border without proper documentation. So, based on the basis of those border emergencies, he claims that there was authority and a basis to impose emergency measures, and those measures would include customs tariffs. So, on just over the weekend, last weekend, Trump issued 3 different executive orders, one with respect to Canada, one with respect to Mexico, another with respect to China. So at 25, 25, and 10%. Generally. However, he, according to news reports, that has now been postponed. Certain border commitments, security commitments, were received from Canada and Mexico just in time, within a few hours of the tariffs set to take effect on Tuesday. They did not happen, but the tariffs with respect to Chinese goods did take effect at 10%. The postponement for Canada and Mexico are until March 4th, about a month away. And at this time, we are not sure what would happen when those 30 days expire, because it leaves Trump the potential opportunity to decide whether or not, unilaterally, that Canada and Mexico have lived up to their commitments. If he decides they have not, then potentially those tariffs will come into effect. Now, these tariffs, if imposed with respect to Canada and Mexico, and as they are being imposed with respect to Chinese goods, are in addition to any other tariffs. So there are already quite a few tariffs that are sort of started in the first Trump administration, which continue through the Biden administration, and which may now further increase or remain. But the other tariffs include the general import duties that are imposed on all goods, regardless of country of origin. And then there are the Section 232 duties that have been imposed since the first Trump administration on certain steel and aluminum products. The steel products are subject to 25% tariff. The aluminum products are subject to a 10% tariff. And that was on the basis of a national security crisis at the time. That was after an investigation. The president determined that there was, in fact, the Commerce Department determined that there was a national security need to impose those tariffs. Section 301 is another provision that allows the U.S. government, through the Office of the U.S. Trade Representative, to conduct investigations to determine whether or not if another country's acts, policies, practices on trade encumber U.S. trade or discriminate against U.S. trade. And after an investigation during the first Trump administration, tariffs are imposed on Chinese products, ranging from 7.5% initially to, ranging from 25% initially to 7.5%. But then some of those goods became subject to even higher tariffs within the past year under the Biden administration. So those tariffs have continued to remain in place with just a handful of exceptions. And those exceptions are currently set to expire in May of this year. And at this time, it's difficult to predict what will happen next. As mentioned, as of the beginning of March, Trump could decide that Canada and Mexico have met their obligations and therefore suspend those tariffs indefinitely, or he might determine that there has not been sufficient active action on the border front, and therefore impose those tariffs. It is interesting to observe that these border-related actions actually target the three largest trading partners of the United States. All right, so we don't. So it seems like an odd coincidence that those are the first ones targeted for these actions. But the the executive order potentially also creates grounds for further escalation in a trade war. And the reason is because each of the orders has a provision whereby Trump promised to potentially expand or increase tariffs if the other country imposes retaliatory measures. And so those retaliatory measures could include counter tariffs, which Canada and Mexico both threatened within hours of the White House announcement initially, before they came to an agreement. And China reportedly has imposed measures in the wake of the White House announcement. And so it remains to be seen what happens there. And so you can imagine a scenario where each country imposes countermeasures in response to the other, and that could suddenly rapidly escalate to fairly severe restrictions and tariff on each of the country's goods. So what happens after the three largest trading partners are subject to these measures? Well, Trump has stated his intention to impose additional tariffs on other countries. At the beginning, you heard Dave talk about the global supplemental tariff to the America First trade policy. Trump, according to news reports, has threatened to impose tariffs on products of the European Union countries. And other countries potentially could become subject to scrutiny because what's been happening since the first Trump administration is that Chinese origin goods, because they were subject to a 25% tariff at times, many manufacturers in China had relocated to Southeast Asia because once goods are made in a different country, if it meets the requirements for substantial transformation, would be considered products of those countries for purposes of assessing a tariff, and therefore avoid the tariff on Chinese origin goods. Well, those countries include Southeast Asia countries like Malaysia, Thailand, and Vietnam. And so there are many observers in the United States who believe that those countries could be next because those are essentially hubs for Chinese manufacturers to relocate and avoid paying that Section 301 tariff. And I'm going to turn next to Dave, where we're going to talk about some of the other laws in the United States Code that allows the U.S. president to impose tariffs and what that may mean for importers.
Thanks, Augustine. So just a couple of things to pause, I think, on with respect to what Augustine just described. You know, after January 20th, we now have a few weeks to see what he's done and assess. We're going to give you sort of a preview in the next few slides about where we're going and what may be coming in the future. But I think it is worth emphasizing a few points about what President Trump and his administration did. One is he imposed tariffs with respect to China on all goods, with no exceptions other than a narrow carve out under IEEPA for certain informational materials and related things that are by statute carved out from IEEPA's scope. But unlike the original China tariffs, at least to date, there's no exclusion process. So you're stuck with them. And because the China and Canadian and Mexican executive orders are more or less parallel, it looks like if tariffs do become imposed on Canadian and Mexican goods, it'll be on all goods with a slightly lower rate for energy-related goods from Canada at 10%. Also, as Augustine noted, it was pinned, and tied explicitly under the executive orders to sensitive political issues, immigration, drug trafficking, the kinds of things that are frankly intractable in the sense that policymakers have been trying to deal with these for years without much impact. And President Trump is basically saying, I am going to impose tariffs depending on whether I feel like Canada and Mexico are doing what I expect them to do with respect to those issues. It's a very difficult bar to meet and makes it difficult to predict where we're going next. And then the other thing is President Trump chose IEEPA as the legal authority to do this and made the tariffs immediate, right? I mean, we got notice on Saturday night as to the content of the executive orders, and with an expected imposition of the tariffs at 12:01 a.m. on Tuesday. So one business day for people to digest and understand what was coming on Tuesday. Obviously, with Canada and Mexico and the deferral for 30 days, there's a bit more time for the business community to assess what might be coming or might not. We don't know what's going to happen in advance of March 4th. So in terms of previewing where U.S. trade policy is going, the slide that we're sharing here provides a summary of significant legal authorities that the White House has to use with respect to trade policy in the United States. As mentioned, over the last week, President Trump chose IEEPA as the legal authority to impose tariffs. One of the things about IEEPA that I think the White House likes is that it allows immediate imposition of tariffs and also allows them, assuming they withstand any legal challenge, allows them to maintain them indefinitely, just by simply reauthorizing or recertifying that the emergency exists with respect to immigration or drug trafficking, as the case may be. So they can sort of put the tariffs into place and hold them there as long as they want, as a negotiating strategy or not. I mean, it's also unclear whether this is purely a negotiating strategy or partly a negotiating strategy and partly just a new industrial policy and way of thinking in the United States. So IEEPA remains possible. The president could issue new IEEPA emergencies with respect to many different political issues, which would allow him, sort of maximum flexibility and authority to impose tariffs if he wants to quickly. To go through some of the other authorities, Section 301, as Augustine mentioned, was the basis for the first Trump administration's imposition of tariffs on Chinese origin goods. Section 301 is intended to address unfair, unjustifiable burdens on U.S. commerce. These are very broad phrases giving the executive branch maximum authority to address what it perceives to be obstacles for U.S. exporters or U.S. businesses. Like in the case of China, the investigation was focused on intellectual property and forced licensing and tech transfers to China. And then that became the basis for imposing tariffs on the majority of imports from China into the United States in the first Trump administration. Some have speculated that President Trump, with respect to China, might use that prior 301 investigation to increase tariffs. That's what President Biden actually did towards the end of his administration. But if he were to use Section 301 with respect to new countries or new topics, presumably he'd have to initiate a new investigation, make findings, and then go through the process of deciding the appropriate remedy for the discrimination that's identified or unfair practices identified. Section 232 are national security related tariffs. This is a statute that's been on the books for quite a while, but was used far more aggressively in the first Trump administration than had ever been used prior to that. The finding there is that the U.S. national security needs are undermined or threatened to be undermined by imports. So in the case of steel and aluminum, in a nutshell, the findings were that trade restrictions were necessary to ensure a defense industrial base adequate to serve U.S. national security. So in terms of the timeline there, again, presumably there would need to be a new investigation of new products and their nexus with U.S. national security. In the first Trump administration, again, that was on steel and aluminum, but there were also investigations on other products, including automobiles and automotive parts. Although those didn't end up resulting in trade restrictions, it's certainly possible that there could be a new subject matter focused investigation under 232. Then there's a couple of other authorities that we highlight here that have never been used to impose tariffs, but are there and on the books. One is Section 122, which is intended to address global balance of payments. So this would presumably be because of persistent trade deficits would allow tariffs up to 15%. Presumably that could be immediate under Section 122 and a finding of global balance of payments. Problems within the meaning of the statute would then authorize the action. Likewise, Section 338 would be for tariffs on countries that discriminate against the United States. These also, upon the finding, could be immediate, although unlike IEPA, for example, I believe those tariffs would have to be temporary, so it wouldn't allow indefinite imposition of tariffs. It would be a temporary tariff. And then there is also potential congressional action here. One thing that's, worth noting in the United States is that Congress has the constitutional authority to regulate foreign commerce and to impose tariffs. And so at any time, Congress could change and effectively overrule what President Trump is doing. There might be some constitutional ambiguities about their authority to do so with respect to national security issues. I would think that kind of issue could be fought out in court, but Congress as a general matter could reverse what the president's doing. One prominent example where Congress has signaled its intent to act is revoking most favored nation status for China. Remains to be seen whether that'll happen. And then another legal basis for tariffs is anti-dumping and countervailing duties, which address unfairly priced or subsidized goods. That requires a 12 to 14 month investigation after a petition is filed or Commerce initiates the investigation.
So Dave, I'm going to chime in here and ask, which of these measures that you see here on the screen have historically been used most to impose tariffs on foreign goods as a special measure?
Yeah, I think anti-dumping and countervailing duties have frequently been used and have sort of been an internationally recognized legitimate basis for the imposition of tariffs, although those are pretty narrowly tailored. Section 301 has been used all the way back through the 80s. It was, a lot of people argue, it was what caused the countries to get together and create the World Trade Organization, because Section 301 was being used frequently and people didn't, U.S. trading partners didn't like it. As a traditional matter, Congress has established tariff policy in the United States. So broadly speaking, I would say congressional action has been the basis for U.S. tariff policy.
That's right, because Article 1 of the U.S. Constitution commits that power to the legislature, does it not?
Right, exactly. So as I said, Congress has the authority under the Constitution to establish these duties. They've given a lot of their authority away in those authorities that were just up on that last slide, which enables the president a lot of room to act.
Right. And of course, as I think we discussed already, IEPA doesn't specify that the president has the authority to impose tariff as a measure to address international emergencies. That is something that Trump has asserted, isn't that right?
Yeah, and one thing, Augustine, people like us and other people in the United States trade bar are looking at right now is, does IEPA actually authorize what President Trump just did with respect to China and might do with Canada and Mexico? And does the statute interpret it? Could you interpret the statute in a way that the White House has interpreted it?
That's right, and that remains to be seen whether there would be a court challenge if these measures persist or expand. Because President Trump, during his first term, briefly tried this with respect to Mexico, but then rapidly rescinded that effort, claiming that there was some kind of arrangement on border security with Mexico. So that did not actually take place. But again, this is, as Dave has said, there are all these other measures that are already available, but they generally require some kind of previous declaration or investigation, with some exceptions. But in this case, IEPA allows them to act quickly, and then there are these other measures that potentially are rarely used, as opposed to the U.S. going to act quickly. Right? Historically, you had a 301 investigation or anti-dumping countervailing duty investigation before any duties are imposed.
Yeah, and I mean, one thing, Augustine, it seems, as you noted, if the tariffs persist, likely that there'll be some sort of court challenge. But I think that the courts tend to move fairly slowly. So in the interim, unless a party is able to obtain a preliminary injunction shutting down the tariffs, then the tariffs remain in effect. And that's essentially what happened with respect to the Section 301 tariffs. Although we're in unprecedented territory here, companies haven't really been able to go into a court and reverse what the White House has done.
That's right. So far, there has not been a challenge to these tariffs, and so it remains to be seen whether what would happen if such a challenge were to arise. I think recently we attended some court hearings, and there's an ongoing litigation in Section 301 tariffs for the holdover from the first Trump administration, where the court asked a question, right? What happens if there's a national security tariff, imposed for a certain national emergency? That was something that one of the judges commented on, and was not an issue ripe for decision in that case. However, it is something that the judiciary may be thinking about should this case arise.
Right. As of today, it is ripe. So we'll see if somebody goes to court, and I suspect if they do, a lot of people would follow them.
So, what could be next, right? So we have what just happened over the last weekend. Canada, Mexico, China were targeted within 2 weeks of Trump's inauguration, and as mentioned, that happens to correspond to the three largest trading partners of the United States. Here is a list from the U.S. Census Bureau. They collect trade statistics, and these are the top 15 trading partners of the United States as of the end of 2024. So Mexico, Canada, and China are the top. The reason why Mexico is at the top, in large part, is because of the tariffs imposed on Chinese origin goods since the first Trump administration. So many manufacturers decide to relocate or diversify their supply chains to Mexico, as Mexico and Canada benefit from duty-free treatment generally under the USMCA that you heard Dave discuss. So and China continues to be on the top three because it is very difficult for supply chains to change out of China. China has many advantages in terms of maybe not so much in low labor costs these days, but certainly established upstream supply chains for materials and other various inputs that are very hard to match. Next you have, of course, Japan, a major U.S. trading partner for many, many decades. Germany and other members of the EU are down there on the list as well. South Korea, Switzerland, surprisingly, is on here. Taiwan, as you may have heard, semiconductors are a hot commodity for international commerce. United Kingdom, Vietnam, and again, Vietnam is one of those jurisdictions that are for a lower cost alternative to manufacturing in China, India, Netherlands, Ireland, EU, Italy, EU, France, EU. So if the trend continues, then we would think that perhaps Trump might turn his attention to these other top trading partners, right? Because if you start with the top three, but in that case, the sort of national security issue was kind of combined with the trade deficit issue, and that comes out in the White House press release that was issued concurrently with the 3 executive orders. That press release talks about the border security issues, but then also mentions in passing the trade deficit issue. So you can see that the Trump White House very much combines those two as one. There's a preference to negotiate on a bilateral basis, and so it could be that these tariff actions are potential leverage for the Trump White House to negotiate with these countries for concessions. right? One-on-one is how they prefer to do it. Um, there's this real skepticism for multilateral organizations by the Trump White House and their supporters. So they really prefer to do a one-on-one. And if, as you saw from the USMCA, which is the replacement for the North American Free Trade Agreement that had been in place since the 1990s, not only not only do they prefer to negotiate with a small group of countries or one-on-one if possible, they also prefer that the trade agreements, if they exist, would only exist for a limited duration of time. And so the USMCA has it would basically auto-destruct unless the three countries come to meet certain deadlines for continuation. And that could come next for other trade agreements. Um, so, and you saw the list from the previous slide. The United States is likely to turn its focus on the European Union, Japan, South Korea, Taiwan, UK, and Vietnam, and for potential negotiations. The United States currently does not have a free trade agreement with most of these countries, with the sole exception of South Korea. There is a ROK-US free trade agreement, but otherwise, EU doesn't. There's not one with the EU or the UK. That effort was blown up during before the first Trump administration, or around that time. There's not one with Japan. Taiwan, there's not an agreement. They're talking about some kind of framework, but it's really not for lower tariffs. And it's the same with Vietnam. As you might recall, the United States pulled out the Trans-Pacific Partnership that had been previously negotiated, and that also happened during the first Trump administration.
So I think it's back to me on this one. We obviously cannot predict the future. But we did think, you know, in terms of looking at what's happened thus far, you know, how does this, based on what we know, what are the relevant facts with respect to Norway? And also with the UK, although we don't have an individual slide on that, you know, as we mentioned on the last two slides, the UK is much higher up there on the level of trade, suggesting that if Trump were to just go down the list, you know, he'd get to the UK, for example, before Norway or other countries. And also, I think really key to one, you know, the summary Augustine gave is that the Trump administration really has this ideology of negotiating on a bilateral basis rather than on a multilateral basis. They feel that the U.S. Negotiating position is at its maximum on a bilateral basis rather than on a group basis. And so that results in them sort of looking at one country at a time. And you saw a lot of this in the first Trump administration, and you're seeing it already in this administration where they're considering each country independently. And, you know, from the United States perspective, or I guess I should say from the Canadian perspective and the Mexican perspective, you know, they're part of a trade agreement with us. So for them to have to negotiate bilaterally is really a different framework than certainly before Trump and even with the Biden administration. You know, they're left basically out of the USMCA. The negotiations take place outside of the USMCA context and take place on a bilateral basis. So what does that mean for a country like Norway? Well, since Norway is not part of the EU, to the extent that Trump were to consider the EU on an aggregate basis, Norway would be left out of that, at least presumably. Although since it's part of the European Economic Area, it's possible that if he did try and do something on an EU basis, he might extend it to the EEA countries as well. It's sort of unclear. But also, aside from the EU, is this issue of NATO. This has become a significant priority for Trump at the international level, has been saying that NATO countries need to boost their defense spending. And because Norway is part of NATO, there could be some trade-related action, I suppose, tied to NATO. we'll have to see. If you assume that President Trump does continue to address these issues on a bilateral rather than any multilateral basis, that would suggest he would look at a country like Norway individually, and probably much later in his administration than we're at now, only 3 weeks into it, just based on the size of trade between Norway and the United States. And so we highlight a few issues that could be the kinds of things the White House would focus on, including issues that are mentioned in the America First Trade Policy Memorandum, which is persistent deficits. That's something that's been true with Norway over the last several years. And then defense spending, again, in the context of NATO. And then energy trade's obviously such a big part of Norway's trade profile that it's possible that, to the extent energy issues are addressed separately, whether it's in 232 or some other legal authority, context of another legal authority, that could become a sort of flashpoint that impacts trade. The other thing is to just point out, as we mentioned a couple of times, that if there were to be a universal tariff on all goods, obviously that would impact Norway just as it would other countries. So that concludes sort of the first part of our presentation. We're going to close the last 20 minutes or so talking about, okay, that's what's happened. That might be what happens if we're trying to project into the future. What can companies do about it? What kinds of things should the business community be thinking about in terms of tariff mitigation or risk mitigation strategies? And with that, I'm going to turn it over to Augustine. As Augustine mentioned, he previously worked at CBP at U.S. Customs. And so he has experience both in government as well as working with people like me in the private sector, helping clients think through tariff mitigation strategies.
Thanks, Dave. As we said, we're going to now talk about some potential strategies to deal with this world of uncertainty that's recommenced, I guess, with the Trump second administration. So what can you do now, right? What happens when the Trump administration, the Trump White House issues an executive order on Friday evening, or promises to issue one over the weekend, and on Monday morning you're faced with one, right? What could you do? So in the short term, here are some things you might want to think about. There are certain basic inputs to what determines a customs tariff, how much is owed on goods imported into the United States. The three key inputs are the tariff classification code and the harmonized tariff schedule of the United States, the HTS-US, which up to the first 6 digits is harmonized with tariff codes used around the world. So Norway and other countries use something similar up to the first 6 digits. And then the remaining 7 through 10 digits are different for the United States, right? But that's something to review because the tariff classification generally determines what tariff rate applies to a product. Country of origin. As we have discussed, these executive orders and tariff actions target goods of particular countries. So that is a key determining factor for what tariffs are owed, whether they'll be subject to these special tariffs, these additional tariffs. Then the customs value. Customs value determines, as you know, is a key input in calculating tariffs. Each of these 3 elements are subject to fairly specific rules under U.S. law, and they are there is actually published guidance, there are published cases, determinations by the agency, that CBP, that in the first instance issues decisions, as well as the courts. So it is not simply a matter of pick and choose. To do this carefully, you would have to look at all these 3 and their in the light of those precedents. CBP, my former employer, imposes what is called a duty of reasonable care on importers. So should they find that there's a violation because of error in declaration, in general, these importers subject to, at the minimum, a potential penalty for negligence in doing so, unless they can show that they have exercised reasonable care. So it is important to also think about those precedents as you review these 3 basic inputs. So beware of any changes, right? As we noted, that there are penalties. So if you determine that, in fact, one of these three elements are wrong in the past and it should be changed in order to take advantage of a more advantageous tariff rate, please note that CBP is on the lookout for potential signs of errors in declarations to impose penalties. So there could be a need to, the customs law does have a provision to get ahead of this issue by submitting a self-disclosure to the government before an investigation starts. So that's something to potentially think about as you review these three elements. And if you have questions, of course, it is recommended that you consult trade counsel or consultants to work in tandem as you conduct this review, because there could be ambiguities that are not evident in the published code. As you conduct this review, you might think about compliance measures, so to make sure things are more consistent going forward, to take advantage of this new rate that you intend to use, so that there are not inconsistencies that could create problems for you, and such as penalties imposed by CBP. In addition to reviewing the basic inputs for determining customs tariffs, what else could you do, right? If you determine that those are not options for you, you can't lower the tariff exposure through either classifying into a different tariff code, finding that it's actually a different country of origin, or that there's an argument for a lower value. You might think about diverting goods, right? Can you divert this shipment to another location, some other friendly market that will not impose the trade restrictions or tariffs on the goods, if that is available? As part of that review consideration, you might ask if perhaps there is space next to the U.S. port, what's called a foreign trade zone. Goods could be entered there as privileged foreign status, which means that they would not be subject to the tariffs, the U.S. tariffs, until the time that they are entered into the U.S. commerce. And if they are re-exported to another jurisdiction, they would never be subject to this U.S. tariffs. Key thing to remember is that the foreign trade zones are not amenable to depositing any goods that are determined to be illegal, unlawful goods. But generally, merchandise could be parked there basically indefinitely and not be subject to U.S. tariffs. And that could create options for perhaps waiting out a tariff action if you think that the tariff action is only temporary and could be suspended later. Or gives you the potential options to think about diverting to other jurisdictions if those opportunities exist. And certainly we would recommend that you think about pausing shipments so they're not, you don't have to deal with incoming shipments as they arise and having to worry about whether they'll be subject to tariffs or perhaps restrictions until the thing is resolved or we have a different solution.
Augustine, one thing that I was wondering you might address is because the tariff rates have changed, essentially the stakes of all of this in terms of potential liability to U.S. customs for an importer at least have gone up, right? So if you're getting something wrong and the tariff rate's 2%, okay, that's, that's X amount of liability. But if it goes up to 27%, that's a lot more liability. So the same error would cause a bigger problem with customs, and also they can look back 5 years. So if you start doing it repeatedly after the tariff rate goes up, that will create a significant liability, several years from now.
That's right. So yes. So U.S. Customs law provides generally a 5-year statute of limitations that CBP could invoke to investigate past shipments. So let's say you have a tariff action, as Dave described, that suddenly increases the tariff, and a company does not, changes its reporting in a way that lowers the tariff exposure that is incorrect. CBP has up to 5 years generally to look at that and investigate and pursue the unpaid duties and assess penalties, right? And the penalties are much higher where if they believe there's willfulness or knowledge involved, intentional conduct. If intentional conduct is involved, it's potentially they could refer it also to criminal prosecution by the U.S. Department of Justice. So there are, in addition to the civil penalties, the civil enforcement powers of the CBP, there are also criminal enforcement measures that are available to the U.S. government. Those investigations will be conducted by ICE, the Immigration and Customs Enforcement, which is a sister agency of CBP. And then prosecution would be pursued in courts by the Department of Justice. So those are real risks that you want to avoid as you consider tariff mitigation measures. This is why it is important to do it diligently so that you pass a reasonable care standard. And if there are close questions, to reach out for help because there are, in many instances, there are published guidance, cases, rules, precedents. It's not simply a matter of finding a favorable provision of the tariff schedule and picking that one. And also same thing with customs value. There are rules that are in in the U.S. code and in the Code of Federal Regulations. They're harmonized with international practices based on past international trade agreements. But again, it has to be based on certain objective standards that are set forth in the rules. It is not arbitrary, and customs is especially focused on potential improperly lowered value for related party transactions, right? So if you have a parent and a subsidiary dealing with each other, CBP is on the lookout for potential valuation issues there.
Yeah. Yeah, and that the valuation that you mentioned, it is harmonized at the international level. It's worth noting that. So if any of you are trade professionals and familiar with non-U.S. jurisdictions, that it can actually give you a good place to start, although you do ultimately want to look at what CBP is doing with respect to particular issues as they might apply to you. So, and we've got about 10 minutes left, a little less than that. There is still a little bit of time. So if you have a particular question, go ahead and put it in the chat box now, and we'll see if we can get it, have time to address it before we conclude here. In terms of medium-term strategies, Augustine went over like things. What can you look at right now that you can look at those customs compliance issues right now to make sure you're doing it right and mitigating risk and reducing your tariff liability to the extent permitted by law. But also you can look at these medium-term strategies that would involve potentially changing your commercial arrangements with suppliers or customers. There are certain exemptions, including under many of the China tariffs, although none other than the narrow IEEPA exemptions available yet. That might change too. I mean, in 6 months, 12 months, Congress could require an exclusion process or something like that, or the administration might create one. You can also ask your supplier to act as importer of record. There are ways for even non-U.S. persons to act as an importer if they do it correctly and in conjunction with an agent and their broker in the United States. You can also amend terms and conditions. One way I've seen that happen is for the parties to reallocate the risk if there's a change in law. That's the kind of thing that seems sort of far-fetched or infrequent, I guess, 10, 20 years ago. But in the current environment, it's very much possible if you reach an agreement with a supplier and you're importing something in the United States, the law could change between when you sign and when the merchandise actually hits the shores of the United States. And then also various other ways to negotiate discounts or pass on costs to consumers, depending on the market that you operate in. Augustine, I think this one's back to you.
Thanks, Dave. And so longer term strategies, right? Things that you could be thinking about now, but will take some time to implement as ways to potentially mitigate risk going forward amidst all this uncertainty. Diversification of suppliers is high up on the list, right? Because these tariff actions, other than the threatened global tariff, typically are assessed against products of one particular country. So if you can diversify suppliers across multiple countries, in particular, if you can find suitable suppliers in the United States, then that could lower that risk that impact of one would harm your business in such a way that you cannot recover. The also, as you consider alternate sources for suppliers, some countries benefit from trade preferences, whether under foreign trade agreements or the General System of Preferences, GSP, for certain countries that may be revived. So that may be available for some of the lower cost jurisdictions. Also, you might wish to consider whether you can relocate manufacturing to somewhere else. So if you were not just buying from a supplier, but you have a vertically integrated supply chain, whether you can move some of those manufacturing operations to a different country. Now, a key thing to remember there is that customs assesses country of origin under applicable rules, whether that's under the trade agreement that has a special provision for origin, or the general substantial transformation analysis. Basically, enough has to be done in the new site of operations for it to be considered good of that country and to acquire a new origin. Otherwise, you may have a compliance problem. You can also, if you're not vertically integrated, you can demand that suppliers, upstream suppliers, diversify their materials and parts suppliers so that they are not exposed and therefore leaving you exposed as the next chain and the next domino in the cycle of dominoes, right? Also, you could look out for potential opportunities to participate in ongoing legal proceedings. As we mentioned, the IAPA has not yet been challenged in this way with respect to tariffs, but there have been cases challenging other tariffs from the first Trump administration. And so that may be something to think about, whether or not there are these opportunities to participate in those proceedings as a co-plaintiff, co-party, of some variety of participant. And then there are also trade associations that have government relations activities that frequently present the case, through political means, political engagement, to argue why these tariffs are a bad idea. So potentially there are opportunities to participate in an applicable trade association and combine your forces with others.
Yeah, and that last one, there are, I think, there's always allies of U.S. companies on Capitol Hill that can be important in U.S. trade policy, whether it's to fight for an exclusion or part of the exclusion process, or carve-outs or exemptions that might apply on a product-specific or industry-specific basis. So we're almost done here. Just to conclude our strategies portion, and then we'll be done, is the long-term strategies that Augustine went over. And then also we wanted to just briefly pause on, is any source safe, here in the United States for imports from this tariff policy and trade policy as it's evolving so rapidly? And in a sense, the answer is no, which is why you want to try and diversify your sourcing to the United States as much as possible. And given what we saw over the weekend, certainly he's willing to impose tariffs very quickly. And so it can, you might not have much time once you become aware of the direction that U.S. trade policy is heading, and could impact your business negatively. Although, it is worth noting that we're just getting, we're only 3 or 4 weeks in here. And so if you're smaller trading partners with the United States, might have a bit more time to watch and learn and see what's likely to happen under the various legal authorities that we saw. I think the America First Trade Policy Memo provides so many avenues for action that we're going to see more and different kinds of action in the space of trade. And so the space is going to continue to evolve pretty rapidly and regularly, I would say, over the next several years. So just concluding remarks, Augustine, anything for the audience as we wrap up?
Thanks, Dave. Yeah, just we have a summary slide here that basically goes through what we discussed the past hour. IAPA allows for sudden imposition of tariffs, right? These are things that are hard to predict. It is a very rarely invoked power, and certainly almost never, I think, no one's remembers it before the first Trump administration and now the second Trump administration. So we've talked about ways to mitigate this risk throughout the second part of the discussion. Selling products to, have a contingency plan in place for multiple suppliers. All right, review your customs practices to think about mitigation strategies and whether or not they're defensible under U.S. law, and reach out to consultants and attorneys when you need to. Dave, do you have anything else?
I think that's it. From me, I really appreciate the chance to talk with everybody today. And very much appreciate the NBCC doing this in conjunction with Dorsey and Whitney. It's been our pleasure. And obviously, if you have any questions or clarifications you'd like from our presentation or down the road for your business, please reach out to one of us and we'll be happy to help.